Welcome to this module designed for those who support employees of federally regulated workplaces who have experienced or are experiencing sexual harassment and violence. Whether you're assisting someone who wishes to file a report under the Canada Labour Code, referred to as the Regulations, or the Canadian Human Rights Act, or you're an employee facing these challenges and seeking to understand your rights, these modules are for you. This series of modules was designed to be completed in separate sessions and for the learner to pick and choose which modules they need to participate in. As such, there is a repeated introductory information in all of the modules in this series. The new content begins at 3 minutes and 20 seconds. This series of modules was developed by Respect at Work, an area focusing on harassment and violence at work at the Centre for Research and Education on Violence Against Women and Children at Western University. The content was created with input from Sexual Assault and Sexual Harassment Centre representatives across Canada, sponsored by the Federal Labour Program, and funded by Employment and Social Development Canada. This module, along with all others in this series, provides information on filing a formal report of sexual harassment and violence under the Canada Labour Code and the Canadian Human Rights Act. It is intended solely for educational purposes and should not be considered legal advice. Although we are focusing on federal legislation, many provinces and territories across Canada have health and safety legislation that includes gender-based violence, including sexual harassment and violence, and intimate partner violence, or IPV, at work. Please review the relative health and safety legislation and human rights laws in your province or territory. Anyone requiring further assistance and advice should seek independent legal advice. This resource is about sexual harassment and violence at work. Some of the content may be upsetting. We recommend reviewing the content in a space that feels comfortable and safe for you. We encourage you to take breaks if and when you need to. If you want to talk to someone for support, please see the toolkit for a list of resources and support services. Please take care while listening. If you are experiencing sexual harassment and violence at work, check your workplace policy. It might have information about where to get support. You can also contact the person or unit in your workplace that has been designated to receive disclosures and provide supports, as well as your union representative if applicable. If you are concerned that there may be immediate harm for you or someone else, call 911. This training is comprised of 3 micro-learning modules designed for you to learn at your own pace, in your preferred environment, and at your convenience. This module will take approximately 22 minutes to complete, and all 3 modules will take approximately 1 hour to complete. The content of the modules is also available as audio recordings. You can find these at itsnotpartofthejob.ca. Under the regulations, employers are required to keep people safe at work, including keeping them safe from sexual harassment and violence. To do this, employers must provide 1. Training and awareness, 2. Policies and procedures related to harassment and violence at work, 3. Conduct a workplace assessment, including the risks of sexual harassment and violence, and 4. Provide clear and safe reporting avenues when sexual harassment and violence occur. Employers must provide free training on harassment and violence, and everyone in the workplace must be trained. This includes new hires, volunteers, interns, board members, and contract workers. Employers must provide a policy on harassment and violence and make it easy to access by, for example, posting it on the company intranet and in the workspace. Workers should be able to consult their workplace policy to learn more. For more information on the minimum requirements of a harassment and violence policy under the regulations, refer to the toolkit on itsnotpartofthejob.ca. When someone experiences or witnesses sexual harassment and violence and wish to report it, they should consult their workplace policy for how and to whom they can report. They can also speak with their health and safety representative, supervisor, manager, or if applicable, their union representative. Importantly, it's their choice whether to report. There are situations where it might not be safe for someone to report experiencing or witnessing harassment and violence at work, and decisions to report should be considered on a case-by-case basis. Employers are also required to complete workplace assessments, which are a key tool in preventing harassment and violence at work. The goal of a workplace assessment is to identify risks, both internal and external to the workplace, that contribute to harassment and violence, including sexual harassment and violence. Examples of possible risks include working in isolation, working long, irregular hours, especially during night and evening shifts, male-dominated workplaces, and workplaces where there are large power differentials between men and women. For example, where men are in managerial roles and women predominantly in lower status positions. Workers may be asked to participate in identifying risks that are specific to their job or work location. To recap, under the regulations, employers must provide training, policies, and procedures, and conduct a workplace assessment related to harassment and violence at work. The rest of this module will discuss the final requirement, which is that employers must provide clear and safe reporting avenues for those who experience or witness harassment and violence at work. Importantly, there is a difference between disclosing and reporting incidents of harassment and violence. Disclosing refers to sharing experiences of harassment and violence with someone at work. It doesn't necessarily lead to formal resolution processes, which could include an investigation. If a worker chooses to share their experience with someone at work, they should be clear about their intentions when disclosing and what, if any, action they want taken. Before disclosing, the worker should ask what actions would be taken if they disclose and whether they have a say regarding next steps. However, it's important to know that employers may be required to act if there is immediate danger to the person or to someone else within the workplace. Reporting refers to formally notifying a person with authority within the workplace about an incident of harassment and violence. The act of reporting might trigger the resolution process as outlined by the regulations. However, if the resolution process is enacted, it must be fully explained to the worker reporting harassment and violence by the employer or their representative, and it must be made clear that the worker has a say throughout the process. To summarize, the differences between disclosing and reporting is that disclosing is when someone shares their experiences of harassment and violence with someone at work, without necessarily wanting formal action, whereas reporting is a formal process of notifying workplace authorities about harassment and violence. Disclosing might force employers to act, for example, if there is an imminent safety risk, whereas reporting can trigger the resolution process outlined in the regulations. People who choose to disclose or report harassment and violence at work should be kept informed about and have input throughout the process. If a worker wants to report sexual harassment and violence at work, they do not have to do it alone. They have the right to be accompanied by a support person. This could be a friend or family member, a spouse or partner, a colleague, or if applicable, a union representative. There are several important things to know about reporting under the regulations. Anyone experiencing or witnessing sexual harassment and violence can report. Reports can be made verbally or in writing. A witness can report anonymously if they would like to. Workers can ask their employer what steps they are taking to protect their privacy. When a worker does report, their employer must provide them with appropriate supports in their community or geographical location. No one should be asked or forced to confront their harasser under any circumstances. If a worker is asked to do so, they have the right to refuse, and their employer must make every effort to resolve the situation. When it comes to reporting, clear communication is essential. All parties involved, including the victim survivor and the person causing harm, must be notified. Additionally, all parties should be kept informed about the next steps in the process. Employers are responsible for keeping workers safe from sexual harassment and violence, both within and outside the physical workplace when the employee is engaged in work activities. This protection extends to incidents involving not only coworkers, but also third parties such as customers, clients, patients, and students. The resolution process includes steps to be taken when a report of sexual harassment and violence is made, with the goals of avoiding further sexual harassment and violence and to keep workers safe. It's important to know that the regulations provide workers with choices throughout the entire process, from reporting to resolution. The resolution process has 4 parts, including the notice of occurrence or report, negotiated resolution, conciliation, and investigation. We will now discuss each part in more detail. You can also refer to the toolkit on itsnotpartofthejob.ca for a link to a summary of the resolution process. We also recommend that workers consult the regulations and their workplace policies for more specific information, including deadlines by which requirements need to be carried out, and when and how all parties will be notified on next steps. The first part of the resolution process is the notice of occurrence or report. This is where the worker notifies the designated recipient, which is the person or unit in the organization that is responsible for receiving reports, a supervisor or manager, or HR representative. This can be done orally or in writing and must include the name of the person experiencing harassment and violence, also known as the principal party, and if known, the person doing the harm, also known as the responding party. The notice must also include the date and a detailed description of the occurrence. Witnesses have the option to notify their employer or representative anonymously if they wish. Once someone has filed a notice of occurrence or a report, their employer must contact them within 7 days to let them know that they have received the report and to explain next steps. If the worker is no longer employed with the organization where they experienced sexual harassment and violence, they can still report it for up to 3 months after leaving the organization. It is still possible to report after the 3-month time frame, but the worker must provide evidence of trauma or health issues that prevented them from reporting earlier. The second part of the resolution process is negotiated resolution. The notice of occurrence is jointly reviewed and assessed for whether the incident fits the definition of harassment and violence in the regulations. That is, any action, conduct, or comment, including of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee, including any prescribed action, conduct, or comment. This includes all types of harassment and violence, including sexual harassment, sexual violence, and domestic violence. This assessment is done jointly with the worker and their employer or designated recipient. If the worker and their employer or designated recipient disagree regarding whether the occurrence falls under the definition of harassment and violence, and if the worker wishes to proceed with the resolution process, the employer is obligated to do so. The employer must attempt to do everything possible to resolve the situation during negotiated resolution. If the report is not resolved through negotiated resolution, workers have the option of seeking resolution through conciliation and/or an investigation. In some cases, conciliation and investigations can occur simultaneously. Conciliation is a process aimed at resolving an occurrence of harassment and violence with help from a neutral third party. In the regulations, conciliation is optional, and both the principal and responding parties must agree to participate and must agree on the neutral third party who facilitates the conciliation. Importantly, conciliation and investigations can occur at the same time. However, this is no longer possible after the investigator submits their report. Workers are not required to engage in conciliation if they do not wish to or feel unsafe to do so. An investigation must be carried out if an incident of harassment and violence is not resolved in the previous stages of the resolution process, or if the involved parties decide not to engage in conciliation. Principal parties, or those who are experiencing sexual harassment and violence at work, can also request that an investigation be carried out. The responding party, or the person who is alleged to be responsible for the occurrence, is required to participate in the investigation. The employer is required to provide notice to the principal party and the responding party of the investigation. An investigator must be assigned within 60 days of when an investigation is initiated. The employer is allowed to appoint the investigator if they have a pre-approved list of investigators that were jointly decided upon with a health and safety committee or equivalent. The investigator they appoint must come from this list. If the employer does not have a list of pre-approved investigators, then they must jointly decide with the principal and responding parties who will act as an investigator. If an agreement cannot be reached within 60 days, the employer can select an investigator from the list provided by the Canadian Centre for Occupational Health and Safety. The investigator must be an independent, qualified, and neutral third party. During the investigation, the investigator will interview the principal party, the responding party, any witnesses, and review documents associated with the report. When the investigation is complete, the investigator will provide a report based on their investigation. The investigator's report must include a description of the incident, their conclusions, and recommendations to eliminate or minimize the risk of similar occurrences happening again. The investigator's report must maintain the confidentiality of all individuals involved, including those connected to the investigation and the occurrence of harassment and violence. The principal party, the responding party, the employer, and the Health and Safety Committee should all receive a copy of the report. Once the investigator's report is received, including their recommendations, the employer must work with the Health and Safety Committee to decide which recommendations from the investigator's report to implement. This process ensures a response but does not provide monetary compensation. If the worker wishes to try to receive monetary compensation, they can seek legal advice for compensation options. To summarize the key parts of the resolution process we just covered. Part 1. Notice of occurrence. This is when a worker reports an incident to someone like a designated recipient, HR, a manager, or a union representative. The employer has 7 days to respond and explain the next steps. Part 2. Negotiated resolution. The employer and worker review the report together to decide if it qualifies as harassment and violence. If the principal party and the employer do not agree, or if the principal party wishes to continue with the resolution process, the employer is required to do so. The employer must do everything possible to resolve the occurrence in the negotiated resolution stage. Part 3. Conciliation. If the issue isn't resolved in negotiated resolution, conciliation may be suggested. This step is optional and only happens if both sides agree to it and to who will act as the mediator. Part 4. Investigation. If conciliation doesn't resolve the issue or isn't chosen, an independent investigator looks into the situation and provides their conclusions and recommendations to prevent it from happening again. The employer must complete the entire resolution process within 1 year of receiving the notice of occurrence and provide monthly updates to both the principal and the responding parties. In situations where the employer is not complying with the regulations and/or does not follow through on a report made by a worker, the worker experiencing sexual harassment and violence can speak with the person handling the report and advise them that the requirements are not being followed. They may want to put it in writing so that there is a record of their concerns. If the report is not resolved and/or if the employer is not complying with the regulations, the worker can also register an occupational health and safety complaint with the labor program. In addition, if the person experiencing sexual harassment and violence at work does not feel as though their complaint was resolved using workplace procedures and their complaint involves a human rights issue, they have the right to file with the Canadian Human Rights Commission. To learn more about filing a complaint under the Canadian Human Rights Act, please see Module 3 in this series for step-by-step information about the process. It's important for the worker to know that the employer and/or their coworkers are not allowed to punish or retaliate against them for filing a report, or providing information to an inspector, adjudicator, federal labor officer, investigator, etc. They are also not allowed to punish or retaliate against the worker for testifying in a hearing or investigation, or exercising or attempting to exercise their rights under the regulations concerning harassment and violence at work. If the worker is being punished, this is called reprisal, and they can file a reprisal complaint with the Canada Industrial Relations Board. If the worker chooses to file a reprisal complaint, they must do so within 90 days. Possible outcomes for filing a reprisal complaint include getting their job back and receiving back pay for lost work time. Remember, the worker who is experiencing sexual harassment and violence at work has a say at every step in the resolution process. This concludes Module 2, Reporting Sexual Harassment and Violence under the Canada Labour Code. Module 3 of the series will explore the process for filing a complaint of sexual harassment and violence and related workers' rights in federally regulated workplaces under the Canadian Human Rights Act. A friendly reminder that the accompanying toolkit is available on itsnotpartofthejob.ca, and we encourage you to refer to it if you are looking for more information on specific supports.